Welcome to Uncommon Knowledge. I'm Peter Robinson. Be sure to follow us on Twitter at twitter.com/UNC Knowledge. Twitter.com/UNC Knowledge. John Yoo is a professor of law at the University of California at Berkeley and a visiting scholar at the American Enterprise Institute. From 2001 to 2003, he served as Deputy Assistant Attorney General in the Office of Legal Counsel in the Justice Department of President George W. Bush. Professor Yoo is the author of a number of books, most recently of Crisis and Command, A History of Executive Power from George Washington to George W. Bush. John, we'll come back to this subject, as we must, but right now, briefly at the top of our conversation, 2 years in the Bush White House that proved intensely controversial. Do you regret any aspect of it?
No, I don't.
All right. Thank you. Segment 1, Crisis and Command. Let's deal with command. I'm quoting from your book, John. When the delegates to the Constitutional Convention met in the summer of 1787, the only thing that made them more uncomfortable than the Philadelphia heat was the topic of the executive. How come?
Well, it's commonly said, which is true, that the colonists rebelled against England because they were upset with King George III. And so people commonly think, oh, well, that must mean the Constitution is an anti-executive document. But it wasn't, because in the period between the Revolution and the writing of our Constitution, our states enacted these terrible state constitutions that tried to weaken the executive. The most famous example comes from my original home state, Pennsylvania, which had 12-member governorships, with each of those 12 people re-elected annually, trying to destroy executive power by weakening it, making it non-unitary, and making it subject. They were all elected by the legislature.
There's a kind of lingering example of that in New Hampshire, where there's a governor, but who has to submit to a governor's council, as I recall.
Yes,
anyway,
yes, exactly. A number of states still have these governor's councils in addition,
right. Mm-hmm.
which are kind of like a superpowered Senate and have to give their advice and consent to a lot of the governor's decisions. And a lot of those people are not accountable to the governor. And so at the time of Philadelphia in 1787, the people who came, the delegates to write the Constitution, weren't reacting against King George anymore. They were reacting against all the problems in the states, and especially one of those being the fragmentation, the weakening of the executive. But at the same time, they didn't want to put a monarchy back in place either. So they had to undertake this new thing, which was how to create a Republican executive.
So they had before them two negative models. The very strong executive of the King of England acting through his, in those days, quite a tight relationship between the king and the ministry, and a weak executive in a number of states which had enacted something like that it just didn't work.
Exactly.
So they had no positive models. That roughly?
They had, the only real example they had to follow was the governor of New York, who had been very successful. And many people, including Alexander Hamilton, thought of, who himself was from New York, thought of the governor of New York as being kind of a model. The governor of New York was independently elected. He wasn't chosen by the legislature, and he wielded very broad powers, especially since the state of New York and the city of New York were occupied for most of the Revolutionary War itself. So the governor, a fellow named, oddly enough, Clinton, Governor Clinton was a very admired but very activist governor. So that was the only real model they had of a successful Republican executive.
And that's more or less what they end up with. Article 2 gives us a president who is independent of both the judiciary and the legislature, and who's elected by all the people.
Right.
Okay, so let me quote again, Crisis and Command. The executive power had been established, you're talking about the Constitutional Convention, so as to allow future occupants of presidency to claim inherent authorities, among them the conduct of foreign policy and the protection of the national security, close quote. I feel the impulse to say, now you're sure of that, Professor Yoo, because so much of the rest of the document is occupied with carefully enumerating powers. Yet you're saying that in Article 2, you've got inherent powers, and that's the way they wanted it.
Well, first, let me compliment you on being a close reader of the Constitution. You've got a good grasp of its text.
Well.
Most of the I don't know if that would get you an A at Berkeley, but it would at Stanford. So, so most of the document,
fighting words,
most of the document, when it talks about Congress, is a careful list of the powers of the legislature, some of which, Congress, I would think today actually has gone beyond, but nonetheless, it has careful list. And compare that to the executive, where the executive power is just granted to the president without a list of what it means. So the listing of Congress says the powers herein listed essentially are granted to Congress. But with Article 2, as you mentioned, it just says the executive power is given to the president, but it's not carefully defined the way it is with Congress's powers. And so two things I try to do is, one, what did executives at the time do? What were their powers? The second is, clearly this is meant to be somewhat elastic, and particularly meant to be elastic in response to challenges, emergencies, crisis, and ultimately war.
And that, John Yoo, is where I thought to myself, I cannot believe what I'm reading. John Yoo is subscribing to the doctrine of the living Constitution.
Well, when the framers wanted a part of the Constitution to be flexible, I think we have to honor that original intention. I don't think the framers wanted every part of the Constitution necessarily to be frozen. Let me also say, though, they didn't think it would be a one-way ratchet. They didn't think the president's powers would grow and then just stay there. I think the president's powers were meant to fluctuate, expand during emergencies, and then during peacetime would retract back to a smaller state, which is, I think, the way the presidency has operated for most of our history.
Segment 2, the two Georges. I'd like to spend most of this segment on George W., no surprise to you. But you begin with executive power in George Washington. How did he make use of these latent or inherent authorities? Briefly.
Yeah. Well, one thing is Washington decided right away that he wasn't going to be a prime minister. He was going to be a president. He did not think he worked for Congress. He didn't think he represented a majority party in Congress. He, in fact, hated political parties. He wanted to maintain the independent stature of his office. So, for example, one of the famous examples is the Senate has the power to give advice and consent to treaties. Washington went once at the very beginning of his administration to actually ask the Senate what it thought.
What do you fellas? What's your advice, fellas?
Yeah, what do you think? Exactly. He said, I want to make a treaty with the Indians. What do you guys think before we negotiate it? He thought it was such a terrible experience that he said he stormed out of the Senate chamber and he said, I'll be damned if I ever show up there again. And that's the first time and the last time a president has ever gone to the Senate in person to talk about advice and consent.
All right, George W. Bush. After 9/11, you note in Crisis and Command, President Bush received from Congress an authorization to use military force. I'm quoting from your book. It was sweeping, perhaps the broadest grant of war power by Congress since World War II. It authorized the president, and now you're quoting from the authorization, to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks. Close quote. Several questions. Number one, for a layman, why did the president request and Congress grant an authorization to use military force instead of his requesting and their enacting a declaration of war, which is the language of the Constitution? It's what FDR requested after Pearl Harbor. Why?
First, let me also make clear that I was one of the people who worked on the authorization when I was in the Bush administration.
So you're quoting yourself cleverly.
Well, the Senate and the House passed it.
All right, all right.
But I did work on it, and I did help with the executive branch congressional negotiations. But the first thing is the United States just doesn't declare war anymore. It hasn't declared war since 1945. And instead it passes these authorizations for force or to use force instead. So Korea...
So you and the president were simply accepting political reality. Would it have been cleaner if you had had your way? Would you have sought a declaration of war?
Well, the other thing is it's not clear to me that a declaration of war was necessary when we were fighting a non-state. We were fighting the Al-Qaeda terrorist organization, which is not a nation, right? And so it seemed to me, in part, declarations of war are for the very purpose of notifying another country, one that obeys the rules of war itself. Here we're fighting a group that's more like pirates. These are not people who follow any of the rules of war. They're not nations. You really negotiate with them. They don't follow any of the civilized rules. So it's not clear to me that a declaration of war is even appropriate for them.
Was the authorization itself necessary, or on your reading of the Constitution, did the president already possess the authority to go after these bandit-like terrorists? Was he merely engaging in a gesture or paying Congress a courtesy?
I think the president already had the authority under the Constitution to react to a direct attack on the United States. But the authorization was a way to build political support, right? To make sure that everyone knew in the country and abroad that the President and Congress are united in their agreement to attack al-Qaeda and take all necessary measures.
So it was merely a political instrument rather than a constitutional necessity.
I think so, yes.
All right. Now, before going into Iraq, President Bush seeks a second authorization to use military force. And this authorization enabled the president, to, quote, defend the United States against the continuing threat posed by Iraq, and B, quote, enforce all relevant United Nations Security Council resolutions regarding Iraq. A, defending us against the continuing threat posed by Iraq, gets taken care of the moment we realize there are no weapons of mass destruction, right? And B, enforcing United Nations Security Council resolutions, that's taken care of the moment 3 weeks into the invasion, Saddam Hussein's government is toppled. So we've got an authorization to use force that pretty clearly, on a layman's reading, authorizes the first 3 weeks of the war, which then goes on for years. Okay, so.
Well, first, Congress never, took the authorization back. It still exists and is in force now because it's commonly thought part of war is also occupying the enemy's territory and restoring the government. And that's more what we're doing. As you say, we have combat operations against Saddam Hussein's regime ended very quickly, and fairly short order it was discovered there were no weapons of mass destruction.
Right.
But there's still the continuing obligation to occupy the country, restore it to some amount of order, and put in some kind of regime.
Would you have liked, I guess there's several possibilities there. One is the president didn't really need an authorization in the first place. So once the specific tasks he had been authorized to accomplish were accomplished, he was still authorized by his inherent powers to remain in Iraq and do what he considered necessary to defend our country and put that one back together. Is that your argument? Would you have preferred it at the time or in retrospect if the president had gone back and gotten another authorization once events had changed? Well, how do you think about the long period when the president seemed to be waging that war? Obviously, this was not the case. He had support among the military, but the press, many members of Congress accused him of waging that war on his own. There was a unilateral quality about it. The other side asserted.
Right. Well, first, constitutionally, I think he could have used force there on his own. And as I point out in the book, presidents have done that before. But I think as a political matter, it was a smart move to get congressional authorization. I think presidents are wise generally to get them when they can because it makes sure that congressmen won't jump off the ship when the going gets tough, which they have almost bred into their DNA. I mean, you had people who had voted for the authorization to go into Iraq attacking the war a mere year or two later just because they didn't like the way it had been going. And so if I think politically, if the president hadn't got those senators and congressmen to vote for it, the eventual surge and sort of victory in Iraq, which I think we're approaching, would have been almost politically impossible.
Okay. Last, put this one to you briefly, if that's not a dirty trick. You write in Crisis in Command, Bush's reputation will depend on whether future historians judge his exercise of presidential power to have been justified by the circumstances, close quote. You're confident they will do so?
I'm not sure. I think I had a lot of questions myself about the Iraq War in terms of strategically whether it made sense to go in. I didn't know, but also the reconstruction of Iraq. I personally favored splitting the country up into three pieces and leaving faster than we did. I thought of it first, though.
Did you really?
But I think that that had a lot of attractions to me. And the administration chose to keep the country whole and to spend more time there. That may end up being the better course of action. I don't know. I think it's way too early to tell.
So there are close and difficult questions there, even in your mind, you who participated in the administration.
Oh, yes, certainly.
Okay. Segment 3, enhanced interrogation. Quoting from a White House press conference that took place in April, question, Mr. President, do you believe that the previous administration, that is the administration of George W. Bush, sanctioned torture? President Obama, what I've said, and I will repeat, is that waterboarding violates our ideals and our values. I do believe that it is torture, close quote. Strictly as a legal matter, was President Obama correct that waterboarding is torture?
Well, I would say I think under the previous administration, it was the view of the government and the Justice Department that it was not. And that was a view I think consistently held.
You recognize the obvious problem for a layman.
Yes.
It's a horrible, gruesome procedure. How do you, as a legal matter, draw the lines, draw the distinctions between what is torture and therefore legally impermissible and what isn't?
It's hard for a lawyer or a layman. I mean, the problem is that Congress passed a law prohibiting torture, and all it did was say torture is the intentional infliction of severe physical pain or suffering. That was it. It didn't list anything about what qualified as torture and what was not torture. There are some people who think in the human rights community that keeping someone in solitary confinement is torture. There are some people who think that physical abuse is torture. Right? So the hard thing for a lawyer is to figure out, well, what's inside and what's outside the line. And I think reasonable people can have differences about it. And this is before you even get to the question of whether it's even a good idea.
Right.
As a matter of policy, just whether it's legal. I think waterboarding is very close to the line, and I think the administration really struggled with the previous administration really struggled with the question.
What did you, as a lawyer, when you were attempting to decide that question, when you were deciding that question, we know that courts in Israel have grappled with these questions for several decades, right? What do you reach for? What do you read? What do you go to?
This is a good question. There's a problem because this statute had never been interpreted by the courts.
The statute dates from?
The early 90s.
All right.
The statute had never been interpreted by the courts. The Justice Department had not prosecuted anyone under it. So there was none of the books off the shelf where you could open up a case or a definition and say, oh, this is what Congress meant. And so we looked at everything. We looked at, as you said, the Israeli experience, the British experience, analogous cases in the United States, and made up a list of the different kinds of cases and what other countries or other contexts people had thought to be torture or not. And I think did our best under the circumstances. Remember, we're only 1 year into 9/11 when our intelligence agency scored the coup of capturing the number 3 person in Al-Qaeda. And everyone thought there were still follow-on attacks planned. I think if you talk to people who lived in New York City after 9/11, everyone would have thought there were going to be more attacks. So I think the pressure on the government was enormous to try to get as much actionable intelligence as possible to stop another 9/11 attack.
Okay, let me continue to quote from that press conference in April. Question, sir, did you read the documents recently referred to by former Vice President Cheney saying that the use of so-called enhanced interrogation techniques not only protected the nation but saved lives? President Obama, I have read the documents. That we got information from these individuals that were subjected to these techniques doesn't answer the core question, which is, could we have gotten the same information without resorting to these techniques? And it doesn't answer the broader question, are we safer as a consequence of having used these techniques? What do you think? Could we have gotten information short of the so-called enhanced interrogation techniques?
First of all, you have to rely on what the people who actually had the intelligence at the time knew, people like the CIA director, people like the president, the vice president, national security advisor. They all have said, I think in public, that this information was important and it did save lives and did stop attacks. I think it's...
Don't you at some level want to just say, President Obama, you are being silly. The security of the nation was directly at risk, and we had people in custody who knew things. If we could get the information, it could save lives. The notion that we have to work our way up some gradual scale and that some set of techniques, which we had already construed as legal, could only be used as a very just ridiculous. You're being silly. Don't you want to say that, John, or not?
I wouldn't say silly. I would say naive. I think it's naive to say, oh, well, maybe we could have gotten it some other way. I mean, you could always say that. You could say, well, if Lincoln had not gone after the South, maybe slavery would have ended on its own and the country would have reunified in 20 or 30 years. I mean, it's impossible to answer a counterfactual like that.
Right.
That's one thing. The second thing is we certainly haven't got a lot of intelligence from operatives who we arrested, brought back to the United States, and put on trial in our federal courts. I mean, you look at what happened to the people responsible for the first World Trade Center bombing. They're still preaching hatred.
The so-called blind
Sheikh
right.
and his followers. We didn't get a lot of intelligence out of them. So I think if you try to do what I think this administration is moving towards, which is give people Miranda warnings, give them a lawyer, bring them back to the United States and put them in trial in New York City, you're not going to get any intelligence that's going to be of great value. In terms of an ongoing war, I don't think it's a bad idea to do all that stuff when the war is over. But when you're in the middle of a conflict, all that intelligence that you can get, anything that comes out in public is enormous value.
So, final question in this segment. Would it be all right with you if President Obama had said something like this? My position is no waterboarding, nothing that a layman would construe as torture, now that the threat no longer seems imminent. But as chief executive, I reserve the right to revisit the situation if the defense of this nation comes under direct threat once again. Would that comport with your notion that there's a certain flexibility here?
Yeah, I think that would actually be the more mature, sensible policy, would be to say, we may do things differently than the last one, but that's because we think the threat is reduced. But if the threat grows again to the point where they can launch another direct attack on the United States, we need to have at least the option of doing these kinds of things again. And I think there are probably people in this administration who think that's what their position is.
I see. All right. Segment 4. This is touchy, John. The case against John Yoo. I want to understand the case and the effect it's had on you. January 2008. Convicted terrorist Jose Padilla files suit claiming he's been tortured in custody, and he names you personally for claiming that you had authorized methods to which he had been subjected and arguing that you therefore were implicated in a violation of his constitutional rights. Is that a fair summary? When that happened in 2008, what was your reaction? Laugh it off because it's such a ridiculous assertion, or?
Well, first I can't, get into the direct merits of the case. It's still on appeal.
It's still on appeal.
But it's not a surprise that, as we've seen almost from the first year of 9/11, that captured members of Al-Qaeda are using our legal system against us. I mean, some people in the Defense Department call it lawfare. They have been filing suits against American officials, not just here, but all over the world. They've been using habeas corpus proceedings in their own trials to force the government to release secrets about what the government knows about them, which is of great value to them. And I think our country still hasn't figured out how to balance our commitment to fair and open trials and legal proceedings with protecting valuable secrets while war is still going on.
Okay, let me ask a few questions and you engage in a lawyer and tell me which questions are permissible and which are not, because the case is still on appeal. So you said that terrorists are using our legal system. It's Jose Padilla's lawyer who came up with this one, I presume. So the question would be, is it lawyers who actually sympathize with the aims of the terrorists, or is it good defense lawyers who look at what the legal system makes available to them and says, I'm going to take the most aggressive route I can, and I'm even going to sue John Yoo? In other words, is it the current state of the legal system itself that all but invites this kind of activity, or do you really have to be a believer in the terrorist cause?
I wouldn't personally say that the lawyers who are representing terrorists, convicted or the ones who go to time, but themselves agree with what the terrorists believe. Any more than I would think, a criminal defense lawyer who's defending a murderer believes that his defendant ought to have murdered someone. I think their lawyers are certainly entitled to use all the available options that the legal system offers. I do think, though, that our legal system used to and should continue to foreclose these kinds of lawsuits. I mean, the biggest problem is that you don't want our officials to be worrying about being sued when they have to make these very difficult decisions about protecting the national security.
On December 7th, the Justice Department, now the Obama Justice Department, asked the 9th U.S. Circuit Court of Appeals in San Francisco to dismiss Padilla's case. Should it have to be the executive branch that asks the judiciary to dismiss a case like that? Shouldn't it got to appeal. The 9th Circuit let that thing go forward.
Well, I actually think that the government here is doing the right thing. I mean, they don't have to enter
the Justice Department is doing the right
Department,
thing, but the 9th Circuit.
Yeah, I mean, part of what concerns me about these kinds of cases in general against the former officials in the Bush administration is that the courts, if they allow these suits to go forward, will get into the business of trying to second guess or review the wartime decisions that people are making while the conflict is still going on. And in the course of doing that, they'll have to produce information in public that could still be harmful to our security. But the second thing is judges, if there's this idea that judges are going to review your decisions and impose liability on you, people are not going to have the full-throated debate you want inside the government. They're not going to make decisions perhaps fully in the national interest if they're worrying about their personal interests. And so you're going to have a risk-averse government. And that's, if you think about it, the kind of mindset we were in about terrorism before 9/11.
Well, so I want to bring you back to the argument on crisis and command. Does your experience being sued, and the case is still on appeal, for decisions you made in good faith as a government lawyer way back in 2002, 2003, what does that tell us about the current state of Article 2 and the inherent strength of the executive? Is it the case that the executive just is too weak to wage, despite all the attacks on George Bush for unilateral, that the fact is that you can't even have lawyers give you an honest opinion without worrying about prosecution in coming years? Is the executive too weak? Is it the case that this current chief executive simply giving away too much of his powers by failing, of the executive's powers, by failing to preserve precedent? What does your experience tell us about Article 2?
Well, first, I think it shows that the idea that we have this imperial presidency who sort of so over-dominates everything and that this is unconstitutional, I just think is quite wrong. I think that these kinds of lawsuits, everything that Congress has been doing for the last 8 years, shows that the other branches can easily check the president and the executive if they want to. Congress, for example, often doesn't want to because they don't want to take the responsibility for tough decisions. I think the judiciary, for most of our history, restrained itself too because they realized these are not the kinds of decisions that they want to second guess, that they don't have the competence to do it, and they don't want to have people looking over their shoulders when they have to make these difficult decisions.
Last question in this segment. This comes from someone who submitted a question for you by Twitter, IDM Architect, anyway, that's a Twitter person. Mr. Yoo, in making your arguments, did you give thought to recriminations or prosecutions by future administrations? Was that in your mind at all back in 2001 to 2003 when you were at Justice?
When I thought about these questions, I knew they were controversial, obviously, and that someday there were obviously going to be people who were going to disagree with them, and who knows what they might do. But I tried to reach the best answer as I could without worrying about...
Did it cross your mind that suit might be brought against you personally?
I mean, I understand the possibility was always there. I would think the legal rules, as I understood them, would foreclose those kinds of suits. That certainly doesn't prevent people from suing.
Does what has happened to you mean that everybody at the Justice Department now is thinking about that in a more concerted way?
Yeah, I worry about that. I mean, I think I would not be, if they weren't.
So you were there in 2002, now it's 2009. In 7 years, we've lost ground. The executive has lost ground.
I think so, and I think this administration, I'm sure the people who are working there, some of whom were lawyers representing members of Al-Qaeda in Guantanamo Bay, of course, they're certainly going to be worrying about this. And I think that will lead them to being more risk-averse than may perhaps be in the nation's interest.
Okay. Segment 5, trying KSM. On November 13th, Attorney General Eric Holder announced that instead of appearing before military tribunals, 5 suspected terrorists, then held in Guantanamo, I guess as we shoot this, they're still in Guantanamo, will be tried in an ordinary federal court in New York City. One of the 5 is Khalid Sheikh Mohammed, by his own admission, the mastermind behind the planning of the 9/11 attacks. I quote John Yoo in an article he published in the Wall Street Journal, quote, "Trying Khalid Sheikh Mohammed in civilian court will be an intelligence bonanza for Al-Qaeda and the hostile nations that will view the U.S. intelligence methods and sources that such a trial will reveal." Close quote. Explain.
Well, the Constitution requires that we have an open public trial for any criminal defendant tried by our government. One of the rights that every defendant has is to force the government to open up its files and say and provide all the information it has on the defendant. So this is not an uncommon tactic. People like Aldrich Ames and Hansen, other Al-Qaeda members, the 9/11, the bombers of the first bombers of World Trade Center, they will all ask the government to put all that information in the public. This is going to be terrible for our efforts against al-Qaeda, because we'll have to explain, for example, how do we know where Khalid Sheikh Mohammed was? Were we able to intercept his cell phones? Were we able to read his emails? How did we capture him? All of that is going to have to be made public. And if that's al-Qaeda will then have great insight into how we're able to keep track of them and how we're able to fight them.
Jim Comey and your former Justice Department colleague Jack Goldsmith in the Washington Post, quote, "In terrorist trials over the past 15 years, federal prosecutors and judges have gained extensive experience at protecting intelligence sources and methods." In other words, John Yoo, relax. "Limiting a defendant's ability to raise irrelevant issues and tightly controlling the courtroom," close quote. Layman Robinson says Yoo says this, a couple other lawyers say relax, don't worry about it.
I think the problem is they don't have examples on their side. I can point you to two. The first is the trial of the blind sheikh.
Which was 495 roughly?
It was in the 90s. More.
Right.
And in the trial of the blind sheikh, the government had to turn over.
Masterminded the first bombing attack on the World Trade. The bomb that blew up in the parking lot. Okay, go ahead.
And the normal process, the government had to provide to the defense a list of all the co-conspirators, the people who we think were helping or conspiring with the defendants to advance their plot. It was a list of some 100-some people, 175, I think. And if you look at it, it was essentially all the people we thought were members of al-Qaeda. And that list was found in Osama bin Laden's safe house. It was just apparently faxed to him just a few weeks later. Think about what an amazing advantage that is for al-Qaeda to look at the list of everyone we think is a member.
All these covers have been blown, and now Osama knows it.
Exactly. And it also tells them who we haven't found yet either. It tells you what plots are ahead, which plots are not. Well, that's one example. The second, even better example is after 9/11. We captured this fellow named Zacarias Moussaoui, the fellow who wanted to learn how to take off in an airplane but didn't care about learning how to land them. And so our FBI, sharp as it is, identified that guy as a problem.
And he was, we now know he would have been the 20th hijacker, but for some logistical mix-up or something.
He didn't get on, wasn't able to get through the training and get to one of the planes. Moussaoui's trial went on for 4 to 5 years. Never saw a single proceeding before a jury because he spent all those years just asking, I want to see all the evidence you have on me. I want to see how you know I'm even a member of al-Qaeda. And he wrapped that court in knots. The only reason the trial ended was because he changed his mind and said, oh, I've decided to plead guilty. There was never any resolution of any of those questions about whether the government could actually try him without having to open up its intelligence files. And I think ultimately they would have had to. John Walker Lind, from just across the bay here, did the exact same thing. And because of that, the government had to reach a plea bargain with him. So I don't think there is any great track record where the government has been able to try actual members of al-Qaeda in our courts.
So what the Goldsmith argument reduces to is, give us a little time, we're experimenting, we're learning as we go along, the correct answer to which is you learn on somebody else's dime. Don't put the defense of this nation at risk.
Especially when there's an alternate system, the military commissions system.
Okay, let me give you another quotation from the Comey and Goldsmith article in the Washington Post. Quote, in deciding to use federal court, the Attorney General, Holder, probably considered the record of the military commission system that was established in November 2001. One reason commissions have not worked well is that changes in constitutional, international, military laws since they were last used during World War II have produced great uncertainty about the commission's validity, close quote. What do you make of that?
Well, I think the problem is that our current federal courts and litigation against them won't let any of these military commissions actually go forward and try someone all the way to judgment. And I'm confident once that happens that people will see that
what happens? Once the federal courts finally...
let a military commission actually hold a real trial. They actually haven't been able to hold a real open trial because the federal courts have been trying to block them or have been...
So what is needed to break that deadlock in the federal bench?
I think it's...
Is there a Supreme Court case that somebody could bring and that would just decide it cleanly with this court?
I think what the Obama administration has to do is let the prosecutors go forward. I think the Supreme Court has said you can now proceed. Congress authorized the commission trials and passed rules of procedure and evidence, so it can go forward now. But then the Obama administration, by moving KSM and his fellow leaders out of that system after hundreds of thousands of dollars and thousands of man hours have been put into their cases, transfer them out, loses even more time. I think that commissions would show that the military justice system is entirely fair, in some ways fairer than our civilian system.
All right. John, you conclude Crisis and Command with sentences that I find surprising. I'll quote them. If Obama wishes to guide the nation successfully through its period of economic crash and foreign threat, he must draw on the mainspring of presidential power as deeply as his greatest predecessors, Lincoln, Washington. So far, John Yoo writes, Obama shows early signs that he has learned this lesson well, close quote. After all that you say, John, you support the Obama administration?
I think that they are coming to their senses in foreign affairs. I think what President Obama said in Oslo and winning the Peace Prize about defending America's right to defend itself, I thought that was a big change from what we'd seen earlier.
He's being mugged by reality as
exactly,
the old line goes.
Exactly. I think the administration came in with some naivete about national security. I think they're getting better at it. I think the decision to send 30,000 more troops to Afghanistan was a wise decision on his part when his base is screaming to pull out of Afghanistan and to pull out of Iraq as fast as possible. He rejected the idea that Afghanistan would be another Vietnam. So I think that in order to achieve success, I actually think the great irony of the Obama administration will be they're cratering on domestic policy. Right now, the newest polls show that less than 50% of the people approve of his job performance. The thing that's going to save his presidency is success, victory in Afghanistan. And it would be ironic, to say the least, wouldn't it, if the great savior of his presidency is the energetic, vigorous presidency exercising national security powers and war powers abroad, which is what Afghanistan is.
John, we will FedEx this segment directly to the West Wing.
I'm sure it'll be watched over and over again, too.
John Yoo, author of Crisis and Command, thank you very much.
Thanks for having me.
Again, be sure to follow Uncommon Knowledge on Twitter at twitter.com/UNC Knowledge. For Uncommon Knowledge, I'm Peter Robinson. Thanks for joining us.